Welcome to the Business SOS podcast. This is Rich Sierra. I'm the president and CEO of the Florida Small Business Legal Center here in Boca Raton, Florida. This is episode 110 of the podcast. Thanks for listening for the last 2 years. I truly appreciate your time, and I hope that the information that I provide to you is valuable to you and to your business. So today we're going to talk about 10 hidden contract traps that could bankrupt your business. I do a lot of contract litigation the last 21 years that I've been in practice. And in many occasions, when you have a breach of contract claims, deals with either misunderstandings as to the term of the agreements, or perhaps a party did not read the terms of the contract, did not understand the contract, or perhaps did not fulfill the obligations. But a good number of times you deal with a situation that, because the contract is long and then has a lot of legalese and terms that a regular business owner or a typical business owner will not understand simply because he or she is not an attorney, they just don't read them. And so I want to go over some items to perhaps bring to your attention as you're reviewing the contract. In my opinion, and I've said this before, if you have a contract that you are reviewing, is something that is important to you or your business, you certainly should have an attorney help you review it and help you understand the provisions of the contract. Ultimately, it is up to you whether or not you want to enter into that transaction, but at the very minimum, you should understand it. And I'll just give you an example. It happened a few weeks ago with a client. The client had a separation agreement that the client went to an attorney, and this attorney happened to represent both my client, and his partner, which is a no-no, but that's a different conversation altogether. And this attorney prepared a contract based on what both of them wanted. And there were consultations, there were advice. I was on vacation when this happened, so I was not involved. So the end result, I get a copy of the contract saying, I want to get out of this. I did not understand the provisions. They have not been paid for this contract. I don't have the information I was supposed to receive. So I'm trying to dig through this and see really what happened here. And what happened is that they were negotiating terms with one attorney. And that clearly creates a conflict of interest. With the attorney, you cannot represent both parties, especially when the adverse interest, unless you have a waiver of conflict of interest. Even with the waiver, it's not a good idea to do that. But they negotiated certain terms. They went ahead and got him signed, got him notarized. And what happened is also there were some additional provisions that they both wanted that were not included there. And now you're dealing with a potential renegotiation, a potential rescission of the contract. It just creates a legal problem in this case. So I'm doing the consultation and getting more information about this. And I spoke with this attorney who helped them draft this contract, and we went over the items of conflict of interest. We agreed to disagree, but it's neither here nor there. I found out there was an additional document that was prepared, which was not given to me originally, and it was an addendum. So there was a contract signed with certain terms, but then there was a subsequent negotiation that took place in which they created some new terms, and they created an addendum that included those terms. They signed it and notarized as well. They did that on their own as well. So, and just to make sure you understand something, when you have a contract and you create an additional document, an addendum, an appendix, or an exhibit to the contract, that becomes part of the contract itself. Okay, so consider one contract. And when you have an addendum, if you disagree with certain terms in that original contract that you signed initially, and then you create an addendum. You're ratifying everything that happened before. So I just want to, I want to make sure you understand that. So unbeknownst to me, there was actually additional terms were included there that were not provided to me initially. So that changes things, because then you're not only dealing with the initial contract, you're dealing with the terms of the new addendum, which is part of that contract. So as I'm talking to this particular client, I'm like, listen, we have an issue here because there were additional terms which were negotiated subsequent to this original contract. In essence, you ratify it. Okay. But fortunately, in this particular case, the original terms of the contracts were not met by the other party. So there are claims for some potential rescission, potential breach of contract claim, potential renegotiations. There's dispute about whether this particular client met the terms of the contract and vice versa. So when you have something like that, you have an opportunity to negotiate certain terms. And that's where we are at now. So the point that I'm trying to make is that, that when you have a contract, you have to understand the terms. When I asked the question, do you understand what you've read? Did anybody explain this to you? No. We just went over it. We signed it. I trusted what the attorney told me, and which is fine. But the attorney was representing both sides, which is not a good idea. And in this particular case, the particular client is not fluent in English. Primary language is Spanish. So that creates an issue as well as to your drafting contracts in English. But at the very minimum, you should have somebody explain to you in Spanish to be able to understand them. You know my rule: if you do not understand a contract, don't sign it. Get advice, get clarification about its terms, so that way you're able to, you'll be able to enter into the transaction with a full and clear mind in understanding what you're signing. So let me go over some of the points that we have here. Okay, one of the things that you have in some contracts, you have non-competes and non-solicitation clauses. Generally speaking, non-compete agreements, you see them in employment agreements, and that in itself is a separate category dealing with employment law. But I want to talk more in the context of separation of a partnership, of a business partnership, or when somebody's selling a business, that you have a non-compete provision that says you cannot open a business with a certain amount of space or geographic area in a specific time period. You also have a non-solicitation clause, which usually is very common. I see them you have vendor agreements, you have an independent contractor agreements as well, in which basically we're going to be doing business together, but you agree not to solicit my employees. You're not going to be allowed to contact my employees, so that way you don't steal them from me. So that's a very common clause as well when you're dealing with vendors or consultants that go into a company and they build a relationship with these employees or key personnel, and then clearly there are opportunities that become available, and then you see their talents. You say, hey, you want to come work for my company, et cetera, et cetera. So those are very common clauses you have there. Nothing technically wrong with them. There's a reason why to have them there is to protect your intellectual property, into your training, your knowledge base, and the training that you provide to these individuals. And also, if you're buying a business, if you're selling your business, it is reasonable for the buyer to say, listen, if you have an Italian restaurant that you're selling to me, say here in Boca, you agree not to open another restaurant within 25-mile radius, for example, for 3 years. Just give you an example. So that way you don't take the customers that I'm buying from you, the customer list or the customer goodwill that I'm acquiring from you, that they don't go to you as a competition. So it's not unreasonable to do that. The same thing, it's not unreasonable to have you as the provider, you're signing a contract with a company, requesting having some type of provision that says you cannot solicit my employees for the purposes of employment. So that, or any purpose. So that way there's no solicitation, you protect your intellectual property, you protect your staff and your training and your know-how from going away from the competition, at least for a period of time. But it's important that if you see them, recognize them and find out why they're there. Okay? Sometimes you have templated agreements that they just included. So just understand if they're there, why it's necessary for this particular individual or company to have a non-compete agreement. Why is it important to have a non-solicitation agreement? If it's something they used in the past, why is it required now? Again, just understand if it's there, ask why, and determine whether or not it's something you want to pursue. I see also non-compete in independent contractor agreements. And that's kind of a touchy subject because independent contractors, by their very nature, they're independent. They can, you don't set their hours, you don't set their schedule, you don't provide any tools. They can do whatever they want. They do an assignment for you. So when you have a non-compete agreement to independent contractors, it can create an issue. As long as it's very narrow in scope, geographic limitation is possibly enforced, but if it's too broad, it might not be enforceable. So just keep that in mind. There are the clauses that I see here, indemnification provisions. You see those, I see them in lease agreements, very common. And as I mentioned, in commercial leases, and when I'm talking about lease agreements here, I'm talking in the context of commercial leases. That's basically what I work with pretty much most of the time. I don't deal with residential leases. It is not uncommon for the landlord to have a provision say that there's any damages or I get sued as a result of, anything that happened in the premises, in your premises that you're leasing from me, you will hold me harmless and indemnify me for any damages, any lawsuits, any claims that might occur as a result of any claims brought against me because of your alleged negligence. That's very common in commercial lease agreements. Understand what it means, and the way to protect yourself from those will be an insurance policy, which is required by the landlord. But it is important when, in this talking about indemnity clauses, then when you have a indemnification clause and a harmless clause, that when you purchase the business insurance or professional liability insurance, whatever insurance you're purchasing to protect your business, to make sure that will cover an event that will trigger the indemnity policy, the indemnification clause. So when you talk to your business broker, in this particular case, I'm using an example of a commercial lease, send the commercial lease to the insurance broker, point out that all the insurance policies you're required to have, point out the sectional indemnification clause and say, I just want to make sure that I'm covered in the event the landlord triggers or invokes that indemnification clause for any events that might occur on my premises. So you just want to make sure of that is a covered event. Again, to the extent that there's nothing wrong with those clauses. They're there to protect whomever needs protection, but it's important you understand that if you sign one of those, you need to protect yourself because it's an event that could happen. You also see them very common when you have a general contractor when hires a subcontractor. to do any work, any type of construction work or construction remodeling. So you see indemnification clauses to the benefit of the contractor in the event the subcontractor gets sued by anyone, whether it's an employee, whether it's the customer. So they end up suing the subcontractor and the contractor. Then you'll have a letter of indemnification to the subcontractor saying you have to indemnify me because I got sued as a result of your alleged negligence. So the key here is for you to understand them and ask questions. Don't just sign blindly on the contract. Another one that I have here is automatic renewals and hidden obligations. This is very common on software agreements or advertising agreements that you pay on a monthly basis. And say if you sign up for a 2-year contract, and in order for you they give you a 30-day exit clause in some cases that you have to send some type of notice to the vendor, a written letter saying, I'm going to cancel the contract, I'm not going to renew. Okay, and if that's usually in a very small print, and usually done in an online agreement that you sign, you get a copy, you put it in your inbox, and you forget about it. Okay, it's important to have the date of the potential cancellation date of that contract if you're not intending to renew it, or if it's a possibility that it's not something that you're going to be using in the future. So that way, you prevent yourself from signing up for another year of service that you do not want. And it's a very simple fix. But, I wanted to make you aware of that because it happens. I'm going to have a lot of automatic renewal contracts in some of the software companies that I use. Some of them are going to be recurrent. Some of them I want to keep an eye on in case I don't want to renew. But it's important to keep those in mind as well. You also have to, if you can, negotiate a shorter renewal period if you want. And in some cases, if you want to cancel before, you can negotiate a liquidated damages clause. And that way, but that's something that you may not be able to negotiate depending on the company, depending on the terms. But being aware of those automatic renewals is very important for you to understand and know where they are. And if you sign those, put in your calendar, 60 days out, take a look at the contract with this company. In the case I want to cancel, I do not want to renew. In fact, I sent an email to a company just this morning that I do not want to renew. How do I do that? To make sure that I put my letter on time so it does not get renewed for another year. Personal guarantees and commercial leases. Okay. I spoken about commercial leases at a great in several podcasts in the past, and I keep bringing this up because it happens very often, very frequently. And next to payroll, I think that the business owner's next large expense would be a commercial lease. It's just a whole different element in the obligations that a business owner has with a commercial lease that it's important to spend special attention, and many business owners do not pay the attention that I believe it requires when you have a commercial lease. They take it very lightly. They just sign, 3 to 5 year contracts with personal guarantees, and then they find out they cannot meet the terms of the lease, and they go ahead and that's when I get involved. What do? I look at the contracts, personal guarantee. So let's talk a little bit. Let's spend some time talking about this. Okay. What is a personal guarantee? Exactly what it means. Okay. If you sign a contract on behalf of your company, the company is obligated to pay. You'll talk about commercial lease. Okay. Let's talk. You sign a lease on behalf of the company is the one obligated to pay. If the company goes out of business, cannot meet its obligations for whatever reason, then the company is the only one liable. If the company decides to file bankruptcy, that's the end of that. You have no individual liability for a corporate debt. Generally speaking, that is the rule. However, if you sign a personal guarantee guaranteeing the performance of the company's obligations, then you are on the hook for the company's obligations for the commercial lease. So when I see a breach of contract claim from a landlord to a commercial, for a client, for a tenant, for breach of a lease agreement, for unable to fulfill its obligations, usually they include as a defendant the client that signed the personal guarantee for breach of the guarantee, breach of contract as well. So that is the way that it works. So again, there's nothing technically or legally wrong with signing a personal guarantee. What happens is that in most cases, especially small businesses, landlords will require a personal guarantee in order to give you the lease. So it's very seldom that you will have a lease agreement with no personal guarantee. It happens, but it's not very often. So I want you to keep that in mind. Now, I want to talk about something called sublease agreements. And this came up this week, actually, as a matter of fact. So we're talking about, going back to that example that I gave earlier about these two partners separating. And one of the terms was that my client was going to take over the lease. And, I said, okay, there's nothing wrong with that. It's sometimes, partners separate and they decide to go separate ways. And one decides to keep the office, the other one decides to go somewhere else. Nothing wrong with that. So I asked the question, I said, well, who has the lease? Who is it? Are you both on the lease, or is it one of you? How is it you're going to basically separate, take over the lease? Is the landlord aware of this? The answer that I got is like, well, none of us are on the lease. And of course, that, as you have heard me before, that will trigger even more questions. And my question is, how is that? So apparently there's another individual in this particular industry who has the lease and is allowing them to work on the space, and they're paying this particular individual the lease payments. And I said, okay, so just to be clear that I'm understanding correctly, there's somebody else who has this lease with the landlord. You're not on the lease. Your partner is not on the lease. And you're paying this individual for your rent. Is that my understanding? The answer was yes. So my answer to that is, well, that's not the way it is done. You can have, the answer they gave me is, well, we made an oral agreement with them that we will pay that, we will take over the space, and we'll do it. And I said, there's no such thing as taking over a space in a commercial lease. There are a lot of implications by somebody taking over a space of a lease and not having a written document which authorizes that individual to conduct business in that space. You're dealing with occupational license issues or business license issues with, now they call it business tax receipt here in South Florida. There are issues with potential liability by not having the insurance required. There's a lot of host of problems, possibly trespassing, because technically you're not supposed to be there in this premises. Either you are an invitee because you're invited to come to the premises as a customer, or you're a business licensee because you basically have a lease agreement. So you cannot just show up to a place and start working without permission, especially conducting business. and you're also conducting business without a license in that particular space. So there's a whole host of issues there that, I can do a separate podcast for, but I'm not going to. Do that maybe another time. But so I said, no, this is not the way it works. Okay. The good news for you is that you're not obligated to stay in that space. You're not obligated to pay anything, because in Florida, dealing with real estate, the contracts must be done in writing. You cannot just have an oral contract to enter into a lease or a sublease. It does not work that way. It's called the statute of frauds. So I said, no, we made that commitment. We want to do it. So, okay, nothing wrong if you want to do it. You're not legally obligated. Now, the way to fix that is that this particular individual needs to give you a sublease agreement. Okay, and that sublease agreement has to be approved by the landlord. The landlord approves the sublease agreement. You sign the sublease agreement. Well, that's fine. Everybody's good. Now, from that sublease agreement, then you can apply for the proper business insurance licenses that you will probably need in order to satisfy the terms of the lease. The landlord is not going to allow you to operate in that space without the proper insurance to protect his or her interest. You also need a business tax receipt. You need to go and get a license to operate in those premises. In a sublease agreement, it is fine. Okay, it's sufficient to get that business license. You will need the lease as well. That is fine. Okay, but you need to have something in writing in order to have the legal authority to conduct business in that particular space. Not just come in and do work here. And this is not something, and then the person was going to have employees come in and work in those premises, which triggers all sets of issues as well, potential workers' comp claims. So think about this scenario. A person comes in, has a verbal agreement to come in and take over a space, no sublease agreements, brings employees to the premises. Something happens to that employee. Person has no workers' comp insurance. Guess who's going to get sued? That particular client is going to get sued for, not having workers' comp to start with. Then the tenant who currently has the lease is going to get sued as well for negligence. The landlord is going to get sued as well. And the client doesn't have business insurance because nobody's going to provide business insurance without a proper lease. So, and again, that is an easy fix to have. So as when you think about cutting corners, that's not one of them. It's not a good idea to enter into a sublease agreement, oral agreement, and then have people work at a space that you're not legally authorized to work from. So so in terms of commercial leases, I want to share with you the personal guarantees. Keep an eye on them. You can negotiate some of the terms of the personal guarantees. Going back to that, you can say, if say you have a 5-year lease and then they say they want a personal guarantee for the 5 years, you can ask, I'll tell you what, if in 3 years I'm in good standing, I pay you every month, can I make that a 3-year personal guarantee? The remaining terms of the lease, I have no personal guarantee. So you can negotiate some of those terms before you sign that lease. Okay? It's difficult sometimes to negotiate a commercial lease, but depending on the landlord's motivation to rent the space, there might be some flexibility. Doesn't hurt to ask, but do it before the lease. And again, with commercial leases, I also recommend you get an attorney to help you understand those terms, because there's a lot of hidden areas, and I say hidden simply because they're not on the first page. I'm not saying that they're hidden on purpose by anyone. Commercial leases are complex documents, and it is important to have somebody who understands them to review them beforehand and help you explain to you your obligations with that commercial lease. So they're not hidden terms as if they can be found. They're on the page, okay? But you have to at least have somebody be able to pull them out for you to tell you, take a look at these items that are important to you, that will be important to you for you to understand them. So that you wanted to leave you that. I think initially I said it was going to be 10 hidden contract traps that could bankrupt your business. We'll leave it at 5 today, simply running out of time. So we talk about non-compete, non-solicitation clauses. We talk about indemnification. We spoke today also about our automatic renewals. We also talk about personal guarantees in contracts, but also personal guarantees on commercial leases. I think this is good for today. I appreciate you listening today. I hope this information was helpful to you. If you have any questions about any of the topics we talk about, or if you have any suggestions about any topics, please let me know. Send me an email at rich@richsierra.com. If you're interested about legal services that we offer here in South Florida, my website is floridasmallbusinesslegalcenter.com. If you like to give us a call, my number is 866-842-5202. We are on Facebook and Instagram at FSB Legal. If you want to see the video of this podcast, you can go to youtube.com/@RichardSierra. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.